Is corporate law different for public and private companies? In today's fast-paced business world, a pressing question arises. Is corporate law different for public and private companies? As more individuals consider investing or starting their own businesses, understanding these distinctions is essential. Just yesterday, discussions around corporate regulations have gained momentum, making this topic highly relevant for entrepreneurs and investors alike. Let's look at how corporate law applies to public and private companies, focusing on business law basics. First, both public and private companies are legal entities separate from their owners. This means owners generally are not personally responsible for company debts or liabilities. Both types must follow state rules for formation, appoint a registered agent, file annual reports, and pay fees. These are standard requirements for any corporation, whether public or private. But there are clear differences in how the law treats public and private companies, especially in areas like regulation, disclosure, and shareholder rights. Public companies sell shares to the public, usually through stock exchanges. Because many people invest in them, public companies face strict rules from agencies like the Securities and Exchange Commission. They must regularly share detailed financial information, disclose material events, and follow rules about how they communicate with investors. These rules aim to protect the public and maintain fair markets. Public companies also have more formal governance structures, with boards of directors and committees that must meet certain standards. Private companies do not sell shares to the public. They have fewer shareholders, often just founders, employees, or a small group of investors. Private companies face fewer reporting and disclosure rules. They do not have to share financial statements publicly or follow the same governance standards as public companies. This makes running a private company simpler in some ways, but it can also make it harder for shareholders to sell their ownership or know the true value of their shares. Another difference is how shareholders can exit the company. In public companies, shareholders can usually sell their shares on the open market. The stock price gives a clear, objective value for their ownership. In private companies, there is no public market for shares, so selling can be difficult. Shareholders may need to rely on agreements with other owners or hope the company is sold. Tax treatment can also differ. Both public and private companies can be structured as corporations, limited liability companies, or other forms. The choice affects how the company is taxed. For example, both limited liability companies and S-corporations are pass-through entities for tax purposes, meaning profits and losses flow to owners' personal tax returns. But public companies are almost always C-corporations, which pay corporate tax before distributing profits to shareholders, who may also pay tax on dividends. While public and private companies share some legal foundations, public companies face much more regulation, especially around disclosure and governance. Private companies have more flexibility but fewer options for shareholders to exit or value their investment. The differences matter for founders, investors, and anyone involved in business law.